once law enforcement issues a ticket or a citation to either a juvenile or an adult, that information is forwarded to the county attorney's office. The county attorney takes the facts that are provided by law enforcement, matches it up to the law, and then determines whether or not a case should be filed in either county court or juvenile court. If the person accused is under the age of 18, then typically it will be filed in juvenile court.
If it is referred to diversion, diversion will reach out to a family. They're going to try and make attempts to bring a youth in and see if they can keep that family, that youth out of the juvenile court system. If there is not an option for diversion, or you miss that opportunity for diversion and the county attorney chooses to go forward, then we'll set it for a first appearance here in juvenile court. The family, the minor, they'll come in, they'll meet with a defense attorney if they don't have one. The public defender will be here waiting for them, have some initial conversations, come into court, and that's the first hearing where we get a chance to go through kind of like what's the possible outcomes in juvenile court, what can happen to you. And then we also have a conversation about your rights that you have. It's a pretty informal hearing. It's just a chance for us to kind of explain what to expect, what's going to happen. If you miss diversion, a lot of times we will say to the county attorney, can this youth be sent back to be screened for diversion? We're trying to figure out what's going to best suit the needs of this kid, this family, at a very early stage, and then how are we going to proceed thereon.
You as a juvenile have the same rights and protections as an adult in the juvenile justice system, or as an adult would have in the adult system. You're entitled to be represented by an attorney, and if you can't afford one, one would be appointed for you. You have a right to remain silent regarding any allegations of any alleged actions on your part. You have to be aware that if you were to say anything, that ultimately could be used against you later to prove those allegations. You're entitled to a trial. At that trial, the state would be required to prove the allegations at the same burden of proof beyond a reasonable doubt as to those allegations.
So you're going to be advised at your first hearing of your constitutional rights, and they are the right to an attorney. If you can't afford an attorney, we will appoint one at no cost to you. It'll require you to fill out a financial affidavit, so we make sure you qualify. Pretty simple paperwork. And if you're entitled to an attorney, we'll appoint one. Sometimes we have to use members in the community that are not part of the public defender's office. Those are private attorneys that agree to do the work, and we pay their bill, not the families, not the kid. But we're going to get you appointed an attorney that knows how to handle matters in juvenile court. The second right is, we'll explain the right to remain silent. If you're asked a question that may cause you to answer showing you've committed an offense, you don't have to answer that. The third right talks about your right to a trial. And if you have a trial down the road, you have a right to cross-examine or question those witnesses. The fourth right that we talk about is, if you have a trial, the kid has a right to testify, or subpoena, meaning force or compel witnesses to come in and testify on their behalf. We have a fifth right that is the right to a speedy trial. In juvenile court, we tell kids, we want to have your case tried within 180 days. Now, there are other guidelines that the Supreme Court tells us that actually is faster. If a kid is detained, we should have that trial within 30 days. So we have other guidelines, but the general rule is no longer than 180 days. And then the final right is, if I make a mistake, if you don't agree with my decision, you always have an avenue to have my decision reviewed, and that would be by appealing it to the Court of Appeals or the Nebraska Supreme Court. What we say in court, everything is typed up by my court reporter, so there is a record that the appellate courts can review what is said, what is discussed in court, but they also get copies of our orders, the decisions that we make, so they can have a review or an opportunity to review and say, yep, Judge Brown got it right. Nope, Judge Brown didn't get it right, so let me correct it. But those are the basic rights that we spell out to the kids when they come into court for their first time.
Juveniles are allowed to have their parent with them at every step in the process in the juvenile justice system. And that's a very important thing to not only judges, but all of us involved in the juvenile justice system. Juveniles have all of the basic rights that adults also share that derive from the United States Constitution.
Per se, you're entitled to the same rights, again, as an adult. You're entitled to be free from unreasonable search and seizures. You're entitled, again, to court-appointed counsel if you can't afford one. You're entitled to a trial as to the ultimate allegations. The state carries that burden of proof at a trial to prove those allegations beyond a reasonable doubt. So you do basically have the same protections or the same Bill of Rights that an adult has in the criminal justice system.
The best way to summarize it is you're going to be treated with ultimate respect, regardless of your preferences, your race, your religion, how you identify. When you step into juvenile court, you're going to be treated with ultimate respect. We are looking for what's best for you. We take into account what the youth wants. We call it a voice and choice. We want to hear, because we have such a limited time with these families. We don't live with them, we don't grow up with them, we don't raise them. So it's really important, the families, the parents, grandparents, uncles, the kid himself or herself, really important that we ask those questions and try to get out those responses of what does this kid and this family need to be successful. That comes from the communication and talking with the family. So the Youth Bill of Rights is really asking, what does this family need to be successful? How do we achieve it? What services can we put in? And we have to be mindful of every kid is different. Every kid has a different background, how they grew up. So how do we best meet the kids given their lived experiences?
The rights advisory typically happens the first time that youth meet with a judge or appear before a judge in court. The rights advisory allows the judge to explain to the youth and their parents all the rights that they would have as they appear and process through the juvenile court system in Nebraska. Those rights could include right to an attorney, right to remain silent, right to call and cross-examine witnesses, as well as a right to call witnesses in their own defense. The goal of a rights advisement is to inform children and their parents of the most extreme or the most serious possible consequences that may result from them being involved in the juvenile court system. The goal of all of the court system is to help children to remain in their home and to keep them safe and healthy. At times, judges are required to remove children from home for different reasons, but we always keep the best interests of children at the forefront of every decision that we make in juvenile court.
Once a petition or allegations are filed with the court, there will be a first appearance hearing where you'll be required to appear before the court, and the judge in the proceeding then is required by statute to advise you of your rights and also the possible dispositions that the court could enter. So the rights advisement is that advisement of what your rights are, what could happen then, the possible dispositions if the court ultimately were to adjudicate in the proceeding.
Talked about that just a moment ago. Rights advisory is the first time a youth comes into court, I have to explain the 6 constitutional rights. That is generally summarizing those 6 fundamental constitutional rights. So we want to make sure the kid understands you have these rights, you have protections. Judges are very mindful of them, and we know we're dealing with young kids sometimes that don't always remember them. So it's constantly reminding. It's sometimes stopping and saying, time out, have you talked to an attorney? Are you sure you want to do this? That's those rights advisory that we're talking about.
There are interpreters available. Once in a while, a family will bring a family member or someone like that who speaks their language. We can't, as a court, use those types of individuals to interpret. We have to utilize certified interpreters, but we do have the availability of those statewide. If they are not available in person, we can video those individuals in, or even have them appear telephonically to provide those interpretation services to parents and guardians.
I feel very blessed being in Nebraska, Douglas County. We have a phenomenal interpreter program. If we are notified, or as soon as we're notified, what is the natural language spoken, we are going to arrange for an interpreter. A majority of the times that interpreter is going to be in person because we have access to those languages. If we have a language that is not as common, Adrian has been able to find somebody in the United States that we can bring in through Zoom. We can have them interpret for the parents while the hearing is going on. The other thing I want you to know is when you walk into a courtroom in Nebraska, we're trying to be better about identifying what you need when you walk in terms of interpreters. So a lot of times you'll see a chart outside the courtrooms that say, this is my natural language. We've had it as simple as somebody pointing to a language, then that gives us notice. If we don't have the interpreter here that day, I will continue the hearing. We will get the interpreter, but I never want a kid or a sibling or family member to interpret. It has to be done by a professional.
It is paramount in the Nebraska both adult court system as well as the juvenile court system that every person who appears or is involved in a case fully understands from start to finish what their rights are and the process in which the case is progressing. So interpreters are always offered through the Nebraska court system. We may have to continue a case if we have to search for a specialized interpreter, but we will always make an effort to make sure that you and your family members or your parent has an interpreter available to understand the entire system. We've gone as far away as the state of Washington for our court here to find a proper interpreter with the correct language that was needed to make sure that the folks in front of the court fully understood what was going on in the process. Usually when you enter the courtroom, a youth will see, one of the first people that they'll actually see is someone involved in courtroom security. That may be someone in a uniform, or it may be someone in plain clothes. They'll typically be standing or sitting near the judge and ensuring that the courtroom is safe for everyone.
I'll start first with the attorneys. The attorneys are there, they have a very specific purpose. Your attorney, the defense attorney, is there to look out for your best interest, what you want them to do. You can tell them and give them your input. It just has to be legal and ethical for them to ask and make those arguments. The county attorney has a job to protect the county or the state. They're there filing the allegations. You could sometimes see what's called a guardian ad litem, or we use GAL, the acronym. A guardian ad litem is appointed to look out for what is best for a youth. Sometimes we don't have parents that are around and they can't make it to court, so we'll substitute a guardian ad litem for a parent when it's needed. And that guardian ad litem role is a little different than a defense attorney. They don't necessarily do what the kid wants, they do what they think is best for the kid, what is safe, what is going to help this kid be successful. Sometimes when we have what we call crossover cases, so if a kid has a delinquency action or you break the law, you come in on a delinquency action. But if there's another type of case, a child welfare type of case, we might have attorneys from that other case. We might have the Department of Health and Human Services. The main role of the attorney is to do ultimately what is best for the kid and help the kid be successful. We're keeping in mind safety, making sure the basic needs of the kid is met, that we're not doing any harm to that youth. You're going to have probation officers, which are really assigned to provide the supervision and help the family navigate all the services the court may order. They're kind of like, you've got an evaluation that needs to be set up. Here's a list of providers. Here are some times. How do we help you get there and get that evaluation? You could have community support personnel in the courtroom, such as a community youth coach. You could have a mentor, a list of community providers that are there to help you navigate, again, those services we want you to be successful in. But they're also really an ally in the courtroom to give the court another perspective of how that youth is doing, rather than just, a probation officer, an attorney. You've got somebody that's meeting frequently with the family, with the kid. You have the judge who makes the decisions. You have a court reporter who is usually seated next to the judge, who their responsibility is to type down the entire record accurately. So if there's ever an appeal, there is a true, accurate copy of what was said, what was decided. And sometimes you may have law enforcement. We try not to have them in here. But if I have a kid who is in custody, then the law enforcement has to be present. Parents, we want family, as many people that can give us a better understanding of what this kid's life has been like and what they need to be successful. But generally, that's the group of people that are in juvenile court.
Well, everybody has a distinct role, obviously. The judges have the role of ultimately being the determiner of fact. The state, the prosecutor has the burden of proving the allegations of any petition. The juvenile, with their counsel, that counsel is appointed for the juvenile, so they represent the juvenile. Parents can bring their own attorney if they choose to. They're not entitled to court-appointed counsel, but they have the right to have their own attorney there as well. If probation's involved, there'll be a probation officer there who will be advising the parties as well, meeting with the youth and their family, and then advising the court as to what they believe would be the appropriate path or disposition for the court to enter.
Absolutely, 100%. That's kind of one of the foundations for the juvenile code and the criminal code is you have an absolute right to an attorney. In fact, I know a lot of people think, I don't know if I need one. I always say this, if you broke your leg, would you try to fix it yourself or would you go see a doctor? And it's no different. If you're involved in court, you have an absolute right to an attorney. Some kids can afford an attorney, their family. Overwhelmingly, we appoint attorneys, and it's at no cost to you. They bill us. We're not telling them how to do their job. That would be a violation of the juvenile code. But we're making sure that the kid is protected. They know every step of the way what they're doing, what's expected, the consequences of it if they don't do them. That comes from being represented by an attorney. And we're not appointing just random attorneys. We're appointing attorneys that have specific experience in the juvenile courts. They understand the different language we use from what kids and families see on TV. And so they're extremely knowledgeable, and they will help guide that youth and that family through the juvenile court process.
And in some instances, that will automatically be appointed for you. In the larger metropolitan areas, we are required by law to appoint attorneys for juveniles when the cases are actually filed. The law also states that if it's a felony offense, all juveniles in the state are also entitled to court-appointed counsel. But if you are in that area where you may be charged with a misdemeanor, one of the rights advisements that the court will give you is that you are entitled to be represented by an attorney, and if you can't afford one, one would be appointed to represent you.
And so typically when we do the rights advisory, which is the initial advisory when children come before the court, we always make sure and explain you have a constitutional right to an attorney. There are times when youth and or their parent disagree with or cannot come to an agreement with their defense attorney. There is a difference between whether or not the attorney is privately retained, which means your family hired the attorney privately, and whether or not an attorney is actually court appointed. If the attorney is court appointed, then you'll have to have a discussion with the judge as to whether or not you have the right to a different attorney and how that process works.
Attorneys have their own ethical obligations that they are bound by. So sometimes your dislike for your attorney may be because they are actually telling you things you may not want to hear. But ultimately, if there's a disruption in that attorney-client relationship, the court would consider appointing you a new attorney.
The general answer is yes. We can't make it a habit because we've really got to keep the process moving to get the services in place to help. We're going to ask the question in the beginning of why do you not like your attorney? Attorneys also themselves have an ethical code they must abide by. If they feel like the relationship has broken down, then we're going to try a different attorney. We're probably going to ask questions of what went wrong with that first appointment, try to figure out is there a specific person we have in mind that may be better suited to help that kid or that family. And so generally, yes, we want to make sure there's a good match. You have to trust your attorney to make this process work. And if you don't have that trust and the respect, then we've got to change it and try something new.
No government-appointed attorney works for the court. Government-appointed attorneys or attorneys that are provided at public expense are paid for by the county in which the case is occurring. So the court does not employ any of the attorneys that you see appearing before it. The court is a neutral third party that basically they call us the referee. I call balls and strikes. I have no interest in what the actual outcome of the case is, except I want every child that appears before me to be safe and healthy.
It may seem a little confusing. The answer is overwhelmingly no. They work for the client. They have an ethical obligation to protect that client. They can't share secrets with us. They can't talk outside of their presence. They are there for them. All we do is we pay them, and it allows for a pool of well-seasoned, experienced juvenile attorneys to be available when we need them, but that's all we're doing is we're paying their bill. When they submit a bill, it's generally categorized. They're not sharing secrets in the billing. It's, I read an email, they don't tell us what it is, and here's the amount of time I spent on it, we're paying that. And we have to ensure that separation to make sure that the system works appropriately. Juvenile court has different language. We don't call things trials, we call them adjudications. You don't plead guilty, you admit. So we have different hearing names. The first hearing you're going to have is going to be a rights advisory or an arraignment. We come in, we tell you what can happen, we tell you your constitutional rights, and then we'll set it for a further hearing. Usually the next hearing is what we call a pretrial. A pretrial is to get the attorneys together with the court and say, what do you need next from us? Are there discovery issues? You don't have all the police reports. Or are we ready to set it for a trial? Sometimes the pretrials can be formal, which means the kid should be here unless the attorney excuses them, or it could be informal, which could be done just over an email or a conference call. Very important in those kind of situations, you're always talking to your attorney. You know, is my attendance required to be there? After a pretrial, we're going to either have a trial date or we're going to have, and again I should say adjudication date, but we'll have an adjudication date and you'll be notified. It's usually in advance. It could be multiple hours or sometimes multiple days. You need to make time in your calendar and schedule. How we typically will do that when it's a significant time chunk of a trial that we're setting, we'll talk with the family. We'll say, can you make this date work? It's going to be for 4 hours, making sure it's not a conflict for school or work. After the trial or a plea, we have that first hearing is called a disposition. Disposition is where we are ordering the probation services that we want to see you complete in order to be successful. We may have a couple disposition hearings. We may be waiting for evaluations and answers from previous service providers to know what you need. After disposition, I've got all the probation orders figured out. I am saying, here's your time frame to complete probation. Then I may have to have what is called probation review hearings. How are you doing with the services I've ordered? But that's generally the hearings that we're going to see. There's some extra hearings if things are not going as well, but those are the most common ones.
In juvenile court, you do not have the right to a jury trial, which would be a jury trial is a trial to your peers. So in juvenile court, we don't have a jury trial. We only have a bench trial, which is a trial to the judge. If the judge determines that you have committed the act that's alleged, or if you admit or plead no contest, then we move on to disposition. At the disposition phase, that would be the equivalent of sentencing if you were an adult.
If it was a trial and the court believes that the state had not met its burden of proof, then the matter would be dismissed. There would be no further proceedings. If it were adjudicated, then it would be scheduled for a disposition hearing. That's the equivalent of a sentencing hearing in adult court, but it's a dispositional hearing. At that time, the court may require probation to complete what's called a predisposition investigation in preparation for that hearing, and the probation office will meet with the youth and their family, and they'll report to the court then what they believe may be the appropriate terms of probation and services or treatment that may need to be included in that probation order. If a juvenile is placed outside of the home, then we're required every 6 months to have a probation review hearing. Again, it would be coming before the court for the court to review the terms and conditions of probation. If the youth has not been returned home by that point, to determine if the youth could safely return home. And then the other hearing would be a potential commitment to the Youth Rehabilitation and Treatment Center, where the court would make a determination of whether youth would have to be placed at our highest level of care in the state, the Youth Rehabilitation and Treatment Centers in Hastings for females, in Kearney for males, and then there's one in Lincoln that is both for males and females with higher acuity needs.
The court does require that any child under the age of 18 that appears before the court has a parent or guardian with them at all times. The court does have the ability to allow that parent or guardian to appear by Zoom, or in extreme circumstances, we've allowed parents to appear by telephone if absolutely necessary, to make sure that that child and that parent understand exactly what's going on at every step in the process.
One of the silver linings out of COVID that we learned is we can operate remotely. That means the courts across Nebraska can use Zoom hearings. We can have, in Douglas County, we have telephone conference lines that we can provide those numbers. So parents, we're going to ask questions in court. Tell us what works best for you. Court operates Monday through Friday, 8 to 5. What works best for your hearing, or to have you attend the hearing? And again, with those remote options, we've had some pretty good results out of that.
We could schedule something over a break, a lunch break, a break that the parents could appear by video. I think the courts are accommodating to do that. We try to be as flexible as possible because we know parents have an obligation or need to be able to support their family as well. And in the rare instances, we then also could appoint a guardian ad litem for the youth to kind of stand in place of the parents if they are just absolutely not able to make it to court hearings.
If you're in contact with law enforcement and you're taken into custody, the first entity that is going to look at you is going to be probation. And they have a screening tool where they go through and they say, can this kid be safely returned to the community? Do we need to put some services in place to help them in the community? And if they can do that, that's the presumption. We want kids at home with their families. If they can be there, they're going to be there. If they can't be safely maintained in the community, then it becomes a question of, should this youth be detained at the Douglas County Youth Center, which is about 42nd and Woolworth. You'll come to court. You're required to have a hearing within 24 hours unless it's a weekend or a holiday. You'll be in front of a judge, and then you will get asked questions on whether or not that youth can be safely returned home, or if that youth it's better that that youth is detained. Now, there are two reasons you can be detained, and it is you have failed to appear in court, and there's a record of that in the last 12 months. The other option is that you are creating a physical threat to the community, the safety and well-being of that community. And those are the two reasons for detention. Detention is designed to be short in time. It is, we've got to try and figure out what we can do to safely get you back to the community. It may be at home, it may be at a shelter, but we're trying to get you out of detention. The difference with YRTC, or the Youth Rehabilitation and Treatment Center, is that is designed for a longer purpose. We have exhausted all the probation efforts that we can. You're not able to be safely maintained into the community. You've been given chances at probation and you're just not successful. Then we use YRTC, which is in Kearney, Nebraska for young men, and Hastings, Nebraska for young women, as a last resort. And it's always a last resort.
The types of things that would potentially lead to detention are if a youth has been ordered to appear in court and they have not appeared, they have willfully failed to appear. That's a basis for detention. I think courts are pretty flexible in allowing probation to utilize less restrictive means. So if the probation office makes contact with a juvenile, they perhaps could put on an electronic monitor in lieu of detention and to give them the youth the next hearing date to make sure they appear at that. And then the other basis for the detention is that the physical safety of persons in the community would be seriously threatened without detention. So there we're talking about items like assaultive behavior, major assaultive behavior, kind of violent types of offenses, and continued use of substances, driving while intoxicated, fleeing from police while operating motor vehicles, those types of things that place the public safety at risk. The YRTC, as I said earlier, those are our youth rehabilitation and treatment centers, and those are our highest level of care in the state. Before a court would commit a youth to the Youth Rehabilitation and Treatment Center, there would be need to have a motion filed asking the court to place the juvenile there. They are then entitled to a separate hearing on that. The burden of proof at that hearing is only by a preponderance of the evidence, meaning the facts are more likely true than not true, but the basis for commitment to the Youth Rehabilitation and Treatment Center would be that probation has exhausted all levels of probation services and community-based supervision, and that the need to place that juvenile there is necessary to, because the juvenile may be likely to flee the jurisdiction, their safety may be in danger, or the safety of persons or property in the community could be endangered. But again, it requires a separate hearing and a separate determination by the court that the state has met its burden of proof in committing a youth to the youth rehabilitation, the YRTCs.
So the highest level of detention would be secured detention, and that would be a facility that would take children out of their home for a brief period of time and hold them until we were able to make sure that the child could safely return to the community and or safely return to their family home.
The court can. Obviously, we have lots of research that shows us that the best place for youth are in the family home, but sometimes continued behavior, continued offenses may require the court to consider an out-of-home placement. But again, that's a separate determination that has to be made by the court based upon evidence. And the evidence again being what we continue to refer to as community-based services. Those services or treatment programs that are available in the community have been exhausted, or the likelihood of them being successful is not there. That would be the basis then for the court to consider an out-of-home placement of a juvenile.
In the juvenile court system in Nebraska, every child is treated based upon their individual facts and circumstances. There is no one cookie cutter answer for how one child may result in detention, and then another child may be allowed to be released at home. So the Nebraska State Probation System is tasked with completing an intake document for any child that law enforcement may believe needs to be removed from home as a result of a delinquent or some form of potential criminal activity. The Nebraska State Probation System works under the court system, and that allows probation to go in and assess a child's risks as well as their needs and determine whether or not that child can safely be returned home with additional services before the next court hearing.
The overriding presumption is we want you in your home to work on the probation orders in the community. If you are not successful, and it's usually over a period of time, we're trying different things, but if you cannot be safely at home, you're creating that physical threat to the community, the court has the authority to remove you from your parental home. There's a wide range of services we could look at using for out-of-home placements. It usually starts with shelter, which is designed to be for 30 to 45 days. Can we correct the behaviors, get some services, and get that kid back to the home after shelter? After shelter, we may have to look at a higher level of care called a group home. Group homes are designed to be 6 to 12 months. It's structure, it's schooling, corrective behaviors, and maybe addressing mental health or substance use needs. A step above that is what we call a PRTF, or a psychiatric residential treatment facility. Kids that are ordered for that are typically the mental health, the diagnoses, and the barriers we've really got to get under control. And then after that, maybe the YRTC that we've talked about. There is also an additional option. We can look at placing you outside of your home. We want to try and use first other family members. Can we get the behaviors corrected with other family members? Then we're going to go to what's called kinship. Somebody you may know, a coach, a teacher, a former daycare provider, a neighbor. Can that placement correct the behaviors? And then last option is we could look at an agency-based foster care. It's somebody you don't know, but it's willing to provide a roof and stability and structure for you. But those are kind of the options we have for out of home. Again, I want to stress the priority and the preference is always to leave a kid in their home.
So the ability to seal a record is one that allows the court to protect children and children in their future life. In that, once a child successfully completes diversion, once a child successfully completes probation, or if charges are dismissed, the court has the ability to seal juvenile cases. That sealing of juvenile cases allows children later in life to go on and be happy, productive citizens and not have to deal with the consequences of something that they did 5 years ago when they were a youth.
I think there's a misnomer or misconception by youth that when we get to that dispositional phase, it's about punishment. While there is an accountability factor in the court entering probation orders, the main focus of dispositional orders and probation orders of the court is for rehabilitative purposes. And so if the youth is placed on probation and they've successfully completed that term of probation, then the law says their record is entitled to be sealed. And the court will do that automatically based upon that fact that the juvenile has successfully completed their term of probation, which then allows the juvenile to tell people, potential employers, things like that, that I don't have any juvenile record, and anyone seeking to find that information wouldn't find it because it is sealed. It is removed from the public domain.
The only people that have access to that sealed record can see it is law enforcement and county attorneys. And they can only see that there was an entry in juvenile court. If they want to get into the specifics, they have to come to your judge and they have to ask for an order to unseal. And we are extremely protective of a use prior record. Thing is, if you're not successful in juvenile court in the initial days and we unsatisfactorily terminate your probation, your record is not sealed. However, because you were involved in juvenile court, you have a right to come to your judge at any time and ask for us to seal your record later. A lot of times what I will say to kids that are not successful is, come see me in a year. Show me that you've graduated high school or got a GED. Show me that you're working and that you have stayed out of contact with law enforcement. If you can give me those things, I will seal your record at a later date. And I really want to encourage kids to do that because they don't understand at this age how an unsealed record is going to impact their lives. So always come back and ask.
I think it's really important that youth and their parents and families who are system involved understand that we treat children in Nebraska differently than we treat adults. We acknowledge and understand that children's brain development and their age determines how and why they make certain decisions. And it's really important that we treat each child individually based on their own particular set of circumstances and needs, which is probably the thing that I love the most about this job. My job literally is to do what's in the best interest of children every single day, which is an amazing part of this job.
The biggest thing is don't be nervous. We are completely different from criminal courts. We are here to help and we want to see kids be successful. The biggest key is when we work together with families, families are communicating to us what their kid needs, what has worked and what hasn't in the past. And it's really important. You have to understand from me, I want to leave you in a better position than I found you. And I do that by us working collaboratively. We talk and we work through those things.
I think the important thing to remember that I mentioned earlier is don't be overwhelmed if you are summoned to juvenile court. Like I said earlier, you're entitled to the full array of rights that an adult is, but ultimately if you're adjudicated, keep that in mind that this is not about punishment. It's about how can we provide you with appropriate services so that you can complete your term of probation, get your record sealed, but more importantly, these things don't continue to occur in the future and keep bringing you back to the juvenile justice system. But more importantly, as you become a young adult, that those things are not a barrier to you being a successful adult and more importantly, not getting involved in the adult criminal justice system.